The one which run number you
Five is a content.
Yes.
Your Worship, here, this matter will be listed on 12 next Tuesday because I have to file a bulk affidavit and I am awaiting some documents, rectified documents. No complaints.
Request of the learned counsel for the response. The matter again on of December 2023. The respondent shall ensure that the affidavit is filed.
That replace the rule set. My lord, passing condition item number 34 and 35. They are heading item by my lord. Let us become of after applications. Immediately after application, my lord.
34 and 35.
Yes, my lord.
Okay. At the request of
That only CGC, my lord.
you are for?
Responding about 3 and 4, my lord. CGC.
The request of the learned counsel, Mr. So-and-so, appearing for the respond number 3 and 4, matter stands adjourned to be listed immediately after the winter recess.
Yes, my lord. Must be. Yeah, bless lordship. Lordship, I would to mention item 17. 17.
Yes.
Lordship, this is I'm struggling to withdraw the revision petition. To withdraw the petition, lordship. So I will.
Mr. Counsel, this has come up for orders. Item number 17 has come up for orders. So obviously, let's see what is the order to be passed. This might be something as regards service and all.
So lordship, I'm going to withdraw.
You want to withdraw 17?
Yes, lordship.
Okay. Mr.
What is your lordship?
Mr. Watizomi, the learned counsel appearing on behalf of the petitioner, submits that he has instructions from his client, from the petitioner, to withdraw the instant revision application. In that view of the matter, the instant writ petition revision application stands closed on withdrawal. Interim order, if any, stands vacated.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 14 on behalf of PJ Sugya. He has some difficulty today. So kindly raise the matter on 12 next week, Your Lordship.
Yes, Minister,
Yes,
you have objection?
no. You see,
Okay. What is this matter about?
the petition is going for portion of the FI.
Washing of the fire.
A similar decision has been decided by Roshini like this. It's reported in changes.
What is there? With the washing?
Lordship,
Hmm?
the council is not here.
The middle meeting of
Yes.
Tuesday. Next Tuesday.
Okay. The request of the Land Council for the petitioner. Matter stands adjourned to be listed again on
Yes.
12th of December.
Lordship, let's interim continue.
The interim order, which was passed earlier, stands extended till the next date.
Please.
Please, Lordship. Lordship, I think to mention item number 29, Lordship, from the supplementary clauses. Lordship, we have received-
29?
yes, Lord.
Yes,
Lordship, we have received the affidavit in opposition filed by the respondent number 2. So can you allow us some time?
what is the matter about?
Lordship, this matter is regarding the check bounce, Lordship.
So we won't look into the affidavit in opposition. It's a case of quashing, if I'm not wrong.
Yes, Lordship.
Is it a case of quashing or what?
Not questioning, Lordship.
Huh?
Lordship,
What? What is this item 29(4)? It's for quashing?
not questioning, Lordship.
What is that? You're challenging some
Not
order.
questioning, Lordship, yes.
So the order has to be tested on the basis of what it is, nothing to do with the affidavit in opposition. Isn't it?
Yes, Lordship.
What do you say?
Lordship, the legal counsel wants to file affidavit in reply, Lordship. Please come on.
It's a scope of filing an affidavit in reply or anything to that effect. So we'll adjourn it to the next date, no further adjournments thereafter.
Lordship,
When do you want it?
Lordship, after vacation, Lordship.
No, nothing doing. I'm not going to look into all these things. I give you a what do you call it, an undertaking that I would not look into the affidavit in opposition. If I am not looking into the affidavit in opposition, where's the scope of filing a reply? What do you say? You are only worried the affidavit in opposition, for which you want to file a reply.
He wants to
I'm
file
not
a-
looking into the affidavit in opposition. You keep it aside. Then,
Lordship, taking the matter had come up on date 15, Lordship.
hmm?
December 15, Lordship. Date 15, December 15th,
When?
December 15, Lordship.
December 15th?
Yes, Lordship.
No. 12th is a very nice day.
Okay, 12, Lordship.
At the request of the Learning Council for the petitioner.
Lordship,
Madam.
Senior's name is not reflected in the cost list.
Huh?
My senior's name is not reflected in the cost list,
So then you go to the registry.
Your Lordship.
At the request of the Learning Council for the petitioner, matter stands adjourned to be listed again on 12th of December. It is made clear that no further adjournment shall be granted in this matter.
Right, Lordship.
Lordship, I think I mentioned item number 5.
21?
Yes, Lordship.
Why?
Lordship, the panel considered for the opinion, his uncle, one of his uncle has expired, so he's living,
With the Oriental Insurance.
so
Home.
opinion, Your Lordship, on behalf of the opinion.
Hmm?
So,
Well, you have to pay some money. Isn't it? Pay that. These matters to be finished off. Don't you think so?
Yes, Lordship, one last opportunity will be granted, right?
Huh?
One last opportunity for hearing.
Okay, we'll have it day after, one last opportunity.
Your Lordship, this matter, on 14th of December.
Why 14?
That's my.
Anything?
Is not for Gauhati. The conference is for Gauhati today, Lordship. So this week, we will be.
Video conferencing, you can do it from Gauhati. What do you say? It's working. We'll have it on Thursday.
Yes, Lordship, please kindly.
Thursday, we finish it off. You have to pay the money, she wants the money.
I'm for the
Uh,
owner, your lordship, honor. No, I'm not for the claimant, your lordship. I'm for respondent number 4, owner of the bank.
So either both of you has to pay. You may say that it is the owner. There must be the license, must be something fake or something must be there. Otherwise, the money has to go. Because otherwise the interest is accumulating.
Yes, Lordship.
At the end of the day. So let's see that the owner gets the claimant gets the money before Christmas. What do you say? Okay, we'll have it on Friday this Friday.
So it's not possible for the appellant concept.
Why? Yeah, I'll help you out. Don't worry. Next Friday. Is the matter at the request of the learned counsel for the petitioner. Appellant on is what? On 8th of December.
I got to mention, I think 22 also. Yeah. I will 22. Go ahead. It's not a this case, Lordship.
Why it has come with?
It's a separate case.
Because the lawyer happens to be the same.
Yes, and the first one is
Friday. Same order, both. Oh, I think it has come as with, so we'll have it too.
This lordship, I beg to mention item number 7 to 11.
7?
7 to 11, your lordship.
7 to 11.
7 will be listed on Thursday. Since the legal counsel for this matter is in leave.
Okay, now what is this review? Review file against whose order?
Against a single judge. Order of the single judge.
Who is the judge who passed the order?
I was retired.
Oh, then I can take it.
Yeah, then we have taken the permission from the.
What is this review about? Is it by the state of Nagaland? Oh, we have a lot of government advocates.
Yes.
So, you be there. Let's see why the matter has come. Thereafter, we'll take.
Your lordship, the legal counsel is in leave in then.
Don't worry, madam.
We had to
If I
move,
have
so.
to allow your matter, I will allow it. If I have not to allow, I will accommodate. So
Lordship.
don't worry, I'll take care of it.
Lordship.
Yeah, state is the applicant here, your lordship.
Huh?
State is the applicant.
State is the appellant. Yes. What is for the state?
Yes, your lordship.
Don't worry, he's there.
Lordship.
Yes, let's start.
Motion, I can move on.
Yes.
This
Committee.
yes, ma'am. This case,
What are you challenging? What are you challenging?
challenging my this in except K. Case me. Yes. 74, my lord.
14/7/2022.
Yes, my lord.
What is that in actual key?
This, my lord, there is my lord, there's a award, my lord, arbitration, my lord, and
Arbitration.
yes, my lord. And
Yeah.
for enforcement, my lord, this maximum case was filed before the principal.
So this was an application filed under 36.
My lord,
You are challenging what order there?
my lord, this, order, my lord, second, my lord.
Gauhati decree sought to be enforced by the decree holder is therefore not a decree of the court within the meaning of 36. The execution is accordingly dismissed.
For enforcement, my lord, filed, my lord, this, examine case, my lord, and 36, my lord. This, my lord, therefore, my lord, this order was passed, my lord, this, as per this honorable, court below, my lord. And this not manageable, and it was my lord, dismissed, my lord. Question is, my lord, at the time, it was expertise award, my lord. Expertise award, my lord, they not done, my lord, we cannot sell, my lord, and
Ex parte not has a challenge on the 34.
no, my lord.
Then how can the authority do that? That the court can do that.
Yes, my lord.
Isn't that okay?
Yes, my lord. This is the case, my
Okay.
lord.
We'll issue notice there.
My lord, this, that is the case, my lord, yes.
Your case is that this is a case where you have got an award.
Yes, madam.
The award has to be set aside in accordance under 34.
Yes, yes, madam.
Without 34, they are moving, they have rejected it.
Yes,
How can the court reject?
Yeah, it's so very time of money execution time. Yes, madam. There's the case.
Okay. Issue notice. Making it returnable by. When are you reopening? You have the 2020.
Fix on 19 of my lord, this come 19 January, my lord.
How do I know it is?
My lord, I check, my lord, I check, my lord, this.
The list, the calendar has come out 2024. Yes, yes.
I have also, my lord.
You have it. No, it is already there. That day in the full court, we have already approved it.
Yes.
Yes, give it to me. And take a photocopy and keep it. Okay.
I'm approved, my lord, it's there, my lord.
Yeah, 2020. Issue notice making it returnable on 19th of January 2024. The petitioner is directed to take steps upon the sole respondent by way of registered as well as usual by you will take the steps by tomorrow?
My lord, 2 days, at least, my lord.
Okay. By 7th of December 2023. You want to stay? Oh, there is no stay.
No.
No stay. Just to put one line out there in the earlier order. The case of the petitioner herein is that the petitioner that an arbitration award was passed amounting to rupees 52,91,887 with interest at a rate of 8% per annum from the date of passing of the award dated 1/9/2014. It is a fair case of the petitioner that without in a application filed under section 34 of the Arbitration and Conciliation Act 1996 for setting aside the award, the lenient court below have nullified the said award by the impugned order dated 14/7/2022. You are challenging under 227.
Yes, madam. Total and I read it, madam, section 5 of Arbitration Act.
Huh?
Yes, madam.
Because 227.
Yes, madam, 227 and read it.
And why there is the delay?
Madam, delay, madam. I have to file separate, actually, I have not, I file separate application, madam.
If it is under 227, there is no separate application, but have you explained it?
Madam, it was not explained, madam. And read it, section 5 of this Arbitration Act, madam, this was.
No, what is this section 5 has to
Yes,
do?
yes, yes.
Section 5 has regards a judicial procedure, judicial proceeding should do it. This has nothing to do with it. How do you explain the delay? The order was passed on 14/7/2022.
Yes, madam, it is, madam.
Then,
Actually, I prepared, my lord,
so we should dismiss it on that ground.
my lord, time.
Why did you wake up so late?
My lord, I will have time, my lord.
Huh?
I'll file the.
You filed it on 22nd of November. And what is there? We are in the month of December.
Actually, some discrepancy was there, so it was, my lord, some there from my juniors, if here, they filed this, my lord.
Till 14/7, where it what did you write? The last line? The last line. It is the case of the petitioner that without the setting aside of an award, the court below had nullified the said by an order dated 14/7/2022, which is not permissible when the said court is enforcing, which is not permissible without the said award being set aside in accordance with the provisions of the Arbitration and Conciliation Act 1996. This court, however, upon perusal of the application, finds that there is no mention, there is no explanation as to why the order dated 14/7/2022 has been filed on, after a lapse of more than a year, on 22/11/2023. Mr. Escamiti, the learned counsel appearing on behalf of the petitioner, submits that he would file an additional affidavit. Yes. Citing the reasons for the delayed filing of the instant application. The issuance of the notice, he may do so on or before the next date. The question of delay and latches and the maintainability of the instant petition is kept open to be decided after hearing the learned counsel appearing the respondents. Yes, what are these? Aids, all aids, petition.
Lordship, the main appeal has been dismissed by this Honorable High Court. These IAs are pertaining to the statutory deposit which has been deposited with the registry in filing the appeal, Lordship, main appeal.
They have deposited?
It is still lying with the registry of this Honorable High Court, Lordship. The appeal was dismissed by the order dated, Lordship, 3/11/2020, Lordship. And the statutory amount is still not withdrawn by the appealing company, Lordship. As such, Your Lordship, we please to allow the applicant company to withdraw the same.
And what is the award? What is order passed? Appeal was filed.
The Honorable High Court has upheld the award of the one traveling, Lordship.
And the amount.
Lordship.
Have you deposited, paid the amount to those people?
Lordship. Lordship, annexure B, Lordship, annexure B, a copy of check, Lordship,
Or payment has been made.
Lordship.
And why there are three, all are three? There are three eyes?
Lordship.
These are three eyes in three different cases.
Different cases, Lordship.
And well, all these are connected.
Connected. Analogous matters, Lordship.
Madam, I'll pass one order, the others will be same in different eyes. The instant application has been filed by the applicant who was the appellant in MAC appeal number 4/2019. At the time of filing the same appeal, the applicant had deposited an amount of rupees 12,500 Oh, 25,000, huh?
Lordship. Into IAS 25,000 and in one IA number.
It's 12,500.
12,500, Lordship.
You just check it out, huh? This I am taking up IA number 142. I deposited an amount of rupees 25,000, which was the statutory deposit. The same appeal was dismissed by this court on 3/11/2020, thereby upholding the award passed by the learned member MACT Dimapur. It has also been brought to the notice of this court that pursuant to the confirming of the award by this court, the applicant had duly paid the said amount to the claimant, as could be evidence from Annexure B to the application. Considering the above, this court therefore disposes of the instant application with a direction to the registry to refund the amount of rupees 25,000, which was the statutory deposit upon an application filed by the applicant along with a certified copy of the instant order. With the above, the instant interlocutory application stands disposed. Otherwise, everything, but just every. And in one case, it is 12,500.
In IA 144, it is 12,500.
All three are disposed.
Highly augmented.
The supplementary questions. For motion item number 23 and 24.
Please, Lordship, I may be allowed some few seconds, Lordship, to call my senior. Please, on court one, Lordship.
What is this IA for?
Your Lordship, my lord, a criminal petition
Oh, no.
has been filed. I do not know why this is in motion.
These matters. You are appealing for whom?
I'm appearing for the petition, my lord.
Oh, okay. What is this IS for?
This IA, my lord, when the matter was being heard on 8th of September, the Honorable Court hearing the matter was of the view that since in view of the allegations made, the CCTV footages and records, my lord, which are evidence, which may be evidence of the allegations made, should be brought on record. And that is why the court wanted it to be as an application to be filed so that the records and CCTV footages may be called. That is how this application is filed.
Why there are two applications?
My
Yeah.
lord,
Why there are two applications? Oh, it's the same application. Okay. Now, what is this matter about, madam?
this matter, my lord, is filed challenging the cognizance of a complaint and a warrant that was issued. Now from the complaint itself, I'm trying to say two things. That one, it is, if we take the complaint prima facie to be correct, it is out and out a civil dispute. And secondly, if at all there is any dispute, sorry, my lord, if at all there is any dispute, it is in connection with a plot of land which is located in the state of Assam in the district of Karbi Anglong.
What kind of a complaint? What business this court has for the purpose of filing the video facilities and all these things?
I'm sorry, I did not get, my lord.
For the purpose of.
My lord, the audio is not working.
Speaks.
My lord, the audio is not working, my lord. I can't hear. Audio is not working. Audio is not working. I could not hear what my lord has said.
I can hear you properly.
Yeah. Yeah, now I can hear.
Okay, you see, this is a case for quashing of a complaint.
Correct.
You know the scope of the jurisdiction before this court. What is this business of calling for a video footage?
Well, the court wanted it, my lord. Even I also have, I also think the same way, but the court wanted it, so I filed an application, my lord.
This court is not going to look into all these things. Are you withdrawing these applications?
My lord, I may withdraw because the scope of the revision petition is whether I can satisfy the court. That's correct, my lord. Because the court wanted, my lord, and it is also reflected in the order. That is why I filed this application.
But then without going into it, let's hear the revision application and dispose it forthwith. What do you say? Whether you make out a case or not.
My lord,
I gets infectious on its own.
my lord, I did not hear the first part. I'm so sorry. Something is not correct. The audio. The first part I did not hear. The second part I heard.
See, it is a case of whether should I take up that I or not.
Lordship.
Yes.
My thing is that if we dispose of the main petition out there, where is the question of the I to be looked into?
Lordship. Lordship.
It doesn't embarrass this court, taking into account that the orders are passed. But the fact remains out here that in proceedings under 482, what is the scope for this court to go into all these things? We can't look into this as regards an inquiry or a video footage out there.
My lord, so far as that application is concerned, that is what I made clear, my lord. This application was filed because the court recorded it and wanted it. I have got nothing really to say on the application because I also know I understand the scope of the revision petition.
Order, why you are challenging this? You are saying that it is a civil dispute. Let's see. Where's the complaint?
My lord, at page 33. I say two things, my lord. One, that it is a civil dispute, and second, that the dispute with respect to the property is situated in the state of Assam. And therefore, courts in Nagaland does not have the territorial jurisdiction to entertain the complaint, even if the complaint is taken to be correct and
Let us go through this. Therefore, the issue is twofold. One is as to whether it's a civil dispute or not, and doesn't come within the ambit of
criminal
offense.
complaint.
And the second is that this court, the courts out there at Nagaland doesn't have the jurisdiction in view of section 177. That's it.
Correct, correct.
Let me read through the complaint.
At page 33, my lord. Paragraph 3, 4. There are two paragraph 3s. Both the paragraphs number 3 and 4.
Yes, what have you done to the money? You received.
My lord.
Have you received the money? The money was paid by check.
The money was not paid by check, but so far as money receipt is concerned, my lord, this is not a single case, my lord. We filed a FIR in Karbi Anglong district, my lord, that if my lord notes at paragraph 3, that a friend of the complainant, namely K. Adhari, my lord, in the first paragraph 3. In this K. Adhari, my lord, whatever had happened, it was with K. Adhari. The complainant does not even know who the complainant is. When he was in the custody, my lord, judicial custody, only then for the first time he met this Nenio in the jail, my lord. The complainant is the petitioner has never met the complainant before. And this K. Adhari, my lord, this is not one case. And therefore, it will require an extensive hearing for which I am also not prepared today, because there are other 4 complaints, my lord. 4 complaints. There 3 in Dimapur, one in the district of Kohima. And this K. Adhari is the proxy who is not in front of the not on papers, and it is this K. Adhari, my lord, who entered into an agreement. And unless that FIR in Karbi Anglong district which I had filed, I said that I have some money to be, taken as loan from K. Adhari, which I need to pay, which I have stated in my FIR my own self. But with Veronica, I have got nothing to do.
No.
Sorry, with this Nenio Mao, my lord, with him, I never had any kind of dealings. Never even met him in my life before I was in custody.
Yes, you were there for whom?
For the respondent, Lordship.
Respondent.
Lordship.
Yes, tell me, what is your case?
Lordship, my case is that, Lordship. Firstly, the complaint is filed against the accused, the petitioner before the Supreme Court, saying that the petitioner has received money from the respondent. And
For selling advance of a land.
Land, Lordship.
Where?
In Assam.
Then
The money was received at the Dimapur.
how? You paid it by check.
Lordship,
That is what the paragraph number 4, that is the mandate.
Lordship, but the money received, Lordship.
Where? Where is the money sit?
There's a page 38 of the petition, Lordship.
I, Anwar Ali so residing at Gauhati, received an amount of ₹6 lakhs in a month from Joseph Nenio so against a plot of land located at Iman, total as advance of Iman. How do you say it is in Dimapur? You have received the money and you have not mentioned in your complaint that it is in Dimapur.
And since the transaction, even otherwise, Lordship, the check, if the petitioner is saying that the check was deposited in Dimapur, and since the respondent, he
The
resides in
check was
Dimapur,
deposited in Dimapur. Where is you? Have you mentioned it in your complaint?
but the respondent, since when it comes to jurisdiction,
No,
Lordship,
when you are filing a complaint, you have to mention to have the jurisdiction. How do you take care of that?
the
First of all, it is a case pertaining to land binding.
Lordship.
You can very well file an FIR, whatever it may be, but how do you make out a claims of complaint and file it out here in Dimapur or wherever you have filed it?
the respondent is a resident of Dimapur.
Maybe.
So jurisdiction,
Just for example, you are in the resident of Dimapur, you want to buy a plot of land out there in Chennai. You give a money, go to have any transactions out there. For a purpose of FIR, it's okay. For the purpose of an FIR, it is okay. But for a purpose of a complaint, whether he will have the jurisdiction in view of 177, have a look at the CRPC. Where is that? No, CRPC, can you give me a copy of it? Every offence shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Where it is uncertain in which of the several local areas an offence is there, where an offence is committed partly in one local area and partly in another, where an offence is committed is a continuing one and continued to be committed, where it may be inquired into having any of it. Now, how do you take care of this when you have not made a single statement out here in your complaint? FI is not an encyclopedia, we know that, but for the purpose of a complaint, it has to be.
Lordship, Lordship, can you give me another date, Lordship?
Tomorrow,
Next week?
day after,
Tomorrow, day tomorrow.
day after.
Lordship, after I've met her in the court more, Lordship, my apologies.
Don't worry, we'll adjourn it for the, we will,
I don't.
the moment
Fine.
we finish it out there,
Yes.
I will accommodate you. Isn't it? But this is the issue. If you have mentioned out there that a check was issued and was paid from Dimapur also, you know, but there is no mention in your complaint that the check was issued from Dimapur or the payment was made at Dimapur. Nothing. Even that document which you are referring to cannot also be taken note of for that.
Lordship, and even
It doesn't say that, yes, it says about the money is to be paid and everything out there, it will be paid. It doesn't say anything. So how do you enter into this? We'll hear you day after. We'll accommodate for you. And madam, I can hear you properly.
Even now I can hear, my lord. At times there's garbling.
The thing is, on Thursday, if I don't hear you properly, that is, you take the risk of doing the matter in that manner. Otherwise, I've heard it. Matter is otherwise very simple,
Yes.
10 minutes of it. We don't require all this eyes and all. Matter having been heard at length. Matter has been heard at length. List the matter again on on 7th of December for further hearing.
I'm grateful, my lord.
I do not invite.
For further hearing and final disposal. Yes, what is this?
This contempt petition is filed for non-compliance of the honorable order date 23/3/2023.
Non-compliance with an order.
This honorable court has. It starts from page number 9, and extra one, your lordship.
What is that?
Yes, your lordship.
Who are you?
I'm an applicant petitioners, your lordship.
All Nagaland PWD Field Workers Association.
Yes, your lordship.
Okay, so and so. What is the direction issue?
Correspondence with that.
Take money in the company, they dispose of with the direction to consider grant of time-bound scale of pay to the members of the petitioners as expeditiously occur within the outer limit of 8 months from the date. Then this copy.
Yes, your lordship.
Copy and close on 8th of month.
Yes, 28th
No,
of
when
March.
did you do it?
8th of March 2023, your lordship. And it's sure.
Okay, 8th of. So, just 8 months has been completed.
Yes, your lordship.
You should notice making it returnable on next year.
Yes, lordship.
18th of January
Lordship.
2023. The petitioner is directed to take steps upon the respondents
In the course of the day, my lord.
by registered as well as usual by registered as usual on or before 8th of December 2023, which
Obliged, my lord.
Motion, I think what this is.
My lord.
Yes.
This is the second application filed under section 411.
Earlier.
It has been rejected by Honorable Justice Kohima, my lord.
You rejected it.
Yes, my lord. Rejected on the grounds that
This is a case under what?
this is a case under kidnapping for section 264 of the IPC. Section 294, section 294, confinement, section 294, section 24, IPC, my lord. Convention, my lord.
Where's the FIR?
Files of batch, my lord, my files of batch.
Page 1.
It's 41 batch 15. If you will come.
Regional,
Yes.
so man in the evening while I was waiting for a passenger, then yes, now what has happened to the victims? Have they been released?
Victims have been
Recovered?
victim has been recovered in the same time. Before the fire was found, the victim has been recovered.
Victims have been recovered. What about the taxi and scooty or what? We can't be, what is there?
Lordship, I'm allowed to produce the CD on the next settlement.
Okay. You have been there inside how long?
16 times, my lord, today.
62 days.
Yes, my lord.
Okay, be there for another 2 more days. We fix it on Thursday.
My lord,
Get the CD.
Right. Possible on Friday, I have not heard my lord Gauhati High Court.
Where?
Gauhati High Court, my lord.
Don't worry. You ask your junior or anybody.
No, it's a review petition. Gauhati High Court.
Mr. Counsel,
My lord.
you want your client to be out or not?
My lord, yes.
You want?
Yes, my lord.
So let us have it on Friday.
Friday, my lord.
Don't worry.
My
We'll
lord.
have it on Friday or ask anybody to appear. If these people have been recovered, what is there inside?
That is my humble submission.
Get that instructions, huh?
My lord.
Issue. So the Mr. So-and-so, the learned PP shall ensure the receipt of the, shall ensure that the FIR, the CD in respect of Dimapur East Police Station, case number 0247/23 is placed before this court on 8th of December 2023. The learned PP shall also obtain instructions as to whether the victims have been recovered and the vehicles in question have been recovered. Where victims and the vehicles in question have been recovered.
No. Also, yes, my lord.
What is your lordship?
Yes.
Lordship, this contempt petition is filed for non-compliance of judgment and order dated 26 to
What is
2023.
that order?
Lordship, the order is at page B 16 and it should be directing the state respondent to pay the compensation of ₹10 lakhs to the petitioner, Lordship. Lordship, we have also sent the notice to the respondents on 6/3/23. However, even after a lapse of 9 months, Lordship, nothing has been done yet. So this contempt petition, Lordship. Lordship, the relevant paragraph of the Court's 81.
That's 6/3. Payment of 10 lakhs within
6 months, yes, lordship.
so it's over. Okay, issue notice, making it returnable on 18th of January 2024. The petitioner is directed to take steps upon the respondents by way of registered as well as usual on or before 8th of December 2023.
Lordship, lordship.
Item number 6.
Yes, civil division. Tell me,
Your Lordship, I received.
what are you challenging?
Lordship, here, the deputy commissioner responded.
And set aside land holding certificate issued by the deputy commissioner and order dated Kohima to the assistant to the deciding the title in favor of the labor department. Okay, tell me,
No, Your
has
Lordship,
the records been called for?
yes, Your Lordship, records.
You are appearing for whom?
I'm for the state, Your Lordship, for the state.
Okay, let's hear the petitioner. Yes, madam. You wanted an adjournment in the morning, no?
No,
Okay,
lordship.
tell me.
Lordship, in fact, my senior, he was supposed to appear, but I think he's
Sorry,
appearing.
you tell me, or 2 words.
So, lordship,
I will then help you out.
lordship.
Yes.
Lordship, here the petitioner village is challenging the order dated 20 November 2021. That is the non-patta that was issued by the deputy commissioner, lordship.
We do one thing. Oh, I have passed a long order. Is an application filed for challenging the order dated when the Land Council has submitted a proposal of the Imam on the case of the vegetable liver has produced various documents including the Now, why the matter has come today? It has come for admission.
Yes, lordship.
It has been admitted. That is why I've already admitted
Yes,
this.
Lordship, what I'm saying is that meantime, Your Lordship, in the Bapro Lake, the DC office was shifted, Your Lordship, to Chimugidima, new district. So the matter was actually falls under Chimugidima, and therefore the files went to the, to DC Chimugidima, and therefore DC Chimugidima has been implemented.
Huh?
DC Chimugidima was implemented in the meantime.
Okay.
And
Then also, it is already admitted.
yes,
And once it is admitted, now we have to call for a record, Mr. Joshua. Has the record been called for?
No, Your Lordship, now the thing is that, Your Lordship, I received some documents, Your Lordship, and it's stated like that the lane, Your Lordship, is a government lane, Your Lordship.
No, then you have to file an affidavit if it is a new. If it is something new which is not there earlier.
Yes, Your Lordship, and it pertains to 1963's, like the government has owned the lane prior to 1963, and
Then the patta was wrongly issued to them.
Your Lordship, it's like this, the land belongs to NIDC as per this document, Your Lordship.
Then?
It's not very legible also. And Your Lordship, and this NIDC has actually entered into a lease agreement with the sugar mill, Your Lordship.
Okay.
And now the labor office has taken over the land from the sugar mill now. So now we have to go to the root now, Your Lordship.
Very well.
So now to complete all this presence, Your Lordship, this court, to go into the facts, Your Lordship, we are actually on the title of the land, Your Lordship.
No, the fact is only the matter is this. There was some form of land settlement given to him. That he claims.
You look,
Let
it's a
us
government land, Your Lordship. It's a
Understood.
public land, Your Lordship.
understood.
Yes, Your Lord.
Where in what land do you give patta?
In sugar mill, we got a permit, Your Lordship.
No, madam, tell me, what land you give patta?
Your Lordship, revenue land, revenue land.
No. You give the land patta only in respect of government lands.
Yes, Your Lordship.
And then it becomes the land of the private. Isn't it out here in Nagaland, all lands belong to the people? It is only those lands which have been either acquired or those lands which have been donated becomes a part of the government land.
Yes, Your Lordship.
Isn't it?
Yes, Your Lordship.
So once these are government lands, how does any other person will get a land? It will be as per the Assam land and revenue regulation.
Yes, Your Lordship. So our labor office, Your Lordship, as of now, will not be able to apprise that issue because, Your Lordship, as far as the document that I received today, Your Lordship, this morning,
Show me. What
it's
document is
not
that?
very legible.
Okay, let us try my glasses. Yeah.
This morning only I received, Your Lordship.
So this is a lease.
Yes, Your Lordship.
A lease given by NIDCL
To the sugar mill, Your
to the
Lordship.
sugar mill. Maybe.
Yes, now. Is the problem now, Your Lordship. It is the issue here, Your Lordship. Sugar mill has given a permit, Your Lordship, to the labor office, Your Lordship.
How does the sugar mill give a
In
permit?
existence, Your Lordship.
How does the sugar mill give a permit?
Your Lordship, sugar mill is also a company, Your Lordship.
So what?
At one point of
But what is the license of the mill?
So that's why, Your Lordship, all this issue will be able to answer by the NIDC because NIDC, if you can kindly turn on the last page, Your Lordship, you will see that it has been issued by the government of Nagaland, Your Lordship, the Pata, Your Lordship.
No, whatever may be.
The land,
But
Your Lordship.
you see, NIDCL may be the owner of the land.
Maybe, Your Lordship.
No,
As
they-
per the- as
No,
per
no,
the
if they are
document.
not the owner of the land, they cannot issue a lease.
Yeah, exactly, Your Lordship.
The lease will be only issued by a
Exactly.
person who is the owner.
Yes, Your Lordship.
Now, if the lease, NIDCL is a party or not?
No, Your Lordship.
Okay, now let us see, what is the impugned order? Let us see.
Imperial order is passed by the DC.
Where is that?
Dimapur.
You are challenging at page 53.
Yes, Your Lordship. That is.
Let us see. This is the order you are challenging, Mr. Joshua.
Yes, Lordship.
Where the office received claim for possession of a land extending the by the entity of the ground and they will have shifted the level of the location. So, then
There, Your Lordship.
Then what are you challenging now? Which is this 24/6/2016, Mr. Joshua? 24/6, this is the Labor Department has a plot of land measuring so and so. And Deputy Commissioner's order. It's 17 November. 2018. Now, where is the title being decided in favor of the authority?
Your Lordship, that
Kindly come to page 55. In the result, I do decide and declare that Sliver has been in lawful possession of the plot of land measuring an area of so and so at Iman, and that AI is entitled to retain such possession. I do strictly forbid any disturbance by Unity Village and further order that the Labour Department, which was forcefully and wrongfully disposed, be restored back. So this exercise of power is done under what? By the EAC?
Lordship, perhaps he has exercised the power under the rules for the administration of.
No, that can't be that.
No.
There is no reference being made, nothing to this logic. Then, don't you think, isn't it required for making of a reference?
Yes, Lordship.
30 or 31 or something to that effect, if I'm not wrong. Then how does this, if this is happening out here, means how can this court under 227 decide these aspects of the matter?
Lordship, for the fact that he has also exercised a jurisdiction which is not empowered upon him by law, and he being an executive officer who has exercised
No, he was only deciding, you asked for what? Yes, so and so, your case is out here, thereby entitling them to claim repossession. You have duly stated that you are not in possession.
Yes,
You want the possession back.
Yes, Lordship.
On one hand, you also admit that the Labour Department was in possession of the land.
Yes, Lordship, in 1997,
What's asking for the repossession? So are you not asking for recovery of possession?
yes, Lordship.
If you are asking for recovery of possession, wouldn't that come within the ambit of a suit?
In fact, Lordship, it should have been an issue for the law court, the civil court to decide.
Absolutely. You are to show before the civil court.
So this decision must go, Lordship.
Decision is not required, so we can you see, whatever it is. So you can challenge this thing also.
There are two things that my Lord may kindly appreciate. Number one, we get the money to the department in 1997, and then we using it. We created the office and left. So we went to the position. And what the things which the department are also not refuting is reflected in the report also. Now, my Lord, if the state only grants the land, the village has no issue over that.
But they have to only use it as a Labour Department.
No, the state authority, the state government's lordship, not the state.
By acquiring it.
But at least the land has to be acquired. That's what we're saying, lordship.
But first of all, you have to be in possession.
yes.
You have a title over that. And who's going to decide that?
No, lordship, this is a very shallow land. And as far as the village is concerned, now I'm trying to do is produce a report of.
That I'm not looking into. I'm not, I'm only on this. Here is a dispute between you and the Labour Department.
Lordship.
There's nothing else. This as to whether NICDCL has given it to the sugar mill or these are other aspects which I am not concerned with. But I am to decide this aspect.
Your Lordship, Sugar Mill has become a unity village now, Your Lordship.
Huh?
Sugar Mill has become a unity village, Your Lordship.
No, not sugar mill area.
Yes, Your Lordship, that area has become a unity village, Your Lordship. Initially, it was occupied and it was like, it's a sugar mill area, Your Lordship. And as per that record, it's a government name, Your Lordship. And now, later on only, there's a document which has been annexed. It has been designated as a unity village, Your Lordship. So, to the root, Your Lordship, unless and then we know the root, Your Lordship, as to how the land has been acquired, Your Lordship. Then only.
Land
we'll able to
acquired by
decide
who?
Is that?
By the state.
Yes, Your Lordship.
Has the state acquired the land? Congratulations.
Confirm that it's.
You are acquiring for the government.
Yes, Your Lordship. It's
Who is in possession now of the land?
now possession of the land, the labor office is still in possession, Your Lordship. They are
So
utilizing.
then the Labour office is rich. Now, if the Labour office is in possession, why there is a direction that I do hereby strictly forbid any disturbance by and further order that the Labour Department land which was forcefully and wrongfully dispossessed is restored back.
Your Lordship, that's why, Your Lordship, this DC order has also, this honorable court has given me a direction, Your Lordship, to produce the record. Accordingly, like, the record from the Labor Office came, Your Lordship, and basing on this order was passed, Your Lordship. Now, the thing is that, like, it's in the possession of the Labor Office, Your Lordship, and now the Unity Village, they start disturbing the office, Your Lordship. They even locked the office, Your Lordship, and that is how, Your Lordship.
Just, we know one thing, the best option is, as it is the case as to whether you are the owner of the land or have a right over the land, can be decided only by leading evidence. It can be done by this court.
So one fact which my lord may cannot appreciate is the Labor Department has not disputed that they took a permit to start the office.
There's no, no, can you listen to it?
Lordship.
The fact as to whether you are the owner or have a right over the land for getting repossession is a thing which can be decided by evidence. In the proceedings under 227, this court is not in a position to take evidence.
Lordship.
Now, this order which has been passed by the authority cannot be an order passed, would be at best an executive order or administrative order or a quasi-judicial order, whatever.
Yes, Lordship.
If I say giving you liberty to go and challenge out there asking for restoration of possession in the civil court, and this order shall not come in the way for in the safe proceeding, I think that is the only win-win I see, because otherwise this matter would keep on pending and you would not get any relief out here. You have to go there.
As my obstruction. So this is done.
No, I am not doing it, but I'm saying this order shall not affect your rights as regards your title.
Lordship.
To be decided in the civil suit.
Lordship.
I think that is the best way.
Perhaps.
This order would be without your prejudice to your rights.
Lordship. Lordship.
Then this can be decided, because this will be at best, this is without taking into evidence of whatever may be, it is a more of an executive order.
My lord.
So, but the fact as to whether you have the ownership or title over the land is a question, or for which you can be given the possession back, is a thing which can be only decided by the civil court.
Yes.
What do you say, madam?
Yes, Your Lordship, that is exactly what I'm trying to say, Your Lordship. It's become a disputed question of fact, Your Lordship. So let it.
This will require a lot of evidence.
Yes, Your Lordship. That's why, Your Lord, let the approach the appropriate forum. That is the civil court, Your
Okay.
Lordship.
Yeah.
What are the appropriate things?
The instant application under Article 227 of the Constitution is filed challenging the landholding certificate dated 24/6/2016 issued by the Deputy Commissioner Dimapur, as well as the order dated 20/11/2021 issued by the what is his name? Extra Sadar / assistant to the Deputy Commissioner, whereby the petitioner village was forbidden from disturbing, from interfering, and a direction was issued that the Labor Department's land to interfere with the Labor Department's land, and which was forcefully and wrongfully dispossessed and be restored back. Upon hearing the learned counsels appearing on behalf of the parties, it appears that the petitioners herein claim rights over the land on the basis of what is your right? On the basis of what?
Lordship, is a village land.
On the basis of the land being a village land.
And the level of
Such has sought for the possession of the said land.
my lord.
Justo. However, by the order dated 21/11/2021, the extra assistant commissioner bracket Sodor held that the petitioner village had failed to produce any cogent and reliable evidence of the documents to substantiate their claim. It was also opined that the Labor Department have been in lawful possession of the land since the year 1993 by running a labor welfare center at the said plot of land. Passport, have you noticed the said impugned order? In my opinion. And said impugned order. And the challenge so made there too by way of the instant proceedings is of the opinion that for deciding as to whether the petitioner village has rights over the land in question and therefore entitled to possession, can only be gone into in a proceedings where evidence can be led as regards the title, as regards the rights of the petitioner village and the corresponding rights of the government of Nagaland over the said land to remain in possession. The impugned order dated 21/11/2021, however, did not deal cannot be seen, cannot be seen to be an order thereby declaring the rights amongst the parties. That merely, the impugn order merely merely decided that the Labor Department has a right to remain in possession on the ground that they have been in possession since 1993. Full stop. One of things that the same order, the impugn order was passed on the basis of an application filed by the petitioner village.
Yes, Your Lordship.
For reclaiming repossession, wherein the authority concerned could have either accepted or rejected the said application. But could not have, in the opinion of this court, asked directions to unlock the gate on or before 22nd of November 2021 for the purpose of the Labor Department to enjoy the possession. This court have also heard the learned counsel, Madam, your name,
Viveka, Your Lordship.
so and so, appearing on behalf of the government of Nagaland, who submits that appeal, the Labor Department of the government of Nagaland is in possession of the land.
Yes, Your Lordship. We are also claiming that it's a public land. We are occupying a public land.
Who?
We are stating that it's a public.
You are in possession of
Yes,
the
Your-
land. Taking into account the above facts, it is the further opinion of this court that if the petitioner wants to regain possession of the land, the same has to be done in a manner acceptable under law. By filing an appropriate suit by filing a suit before the appropriate forum for seeking appropriate declarations as regards their ownership over the land, as well as for seeking recovery of possession.
Madam.
Mr. Joshua Siki, appearing on behalf of the petitioner, submits that he would duly advise the petitioners to do the needful. Taking into account the above, this court therefore disposes of the instant petition by holding that the impugned order dated 21/11/2021
Lordship, the land holding certificate 24 June 2006.
as an order which has been passed not in accordance with the well-settled principles of law. The reasons already above mentioned. Further, he takes note of that the Labor Department of the government of Nagaland is presently in occupation of the land.
Yes.
And under such circumstances, this court grants the liberty to the petitioners to approach the appropriate court to seeking declaration as regards the ownership of the land, declaration as regards the ownership or rights of the petitioners over the land.
Madam.
And for recovery of possession.
Or compensation. If my lord may kindly add.
Eh?
Or compensation if the state wants to occupy, lordship.
Because you have to first sue your right, then compensation. How do I know that you are going to win?
Lordship.
This court further also finds it relevant. No, just like before parting with the record, this court finds it also relevant to note the submission of Mr. Joshua Seki as the learned counsel for the petitioner, that the petitioners herein have also challenged the land holding certificate dated 24/6/2016.
My lord.
Issued in favor of the Labor Welfare Office, Department of Labor, Government of Nagaland. As already stated herein above, the petitioners have been stated above. The land holding for setting aside and quashing the land holding certificate it is the requirement that this court, no, the certificate, the petition, it would require entering into the arena of disputed questions of facts, as well as also looking into detailed evidence as regards the rights of the petitioner village over the land in question. Under such circumstances, since CNS, the petitioner village proving its rights over the land, the question of setting aside the land holding certificate does not arise. The petitioners, however, is granted the liberty to challenge the land holding certificate in such appropriate proceedings, wherein the petitioners seeks appropriate declaration and recovery of possession.
No, Your Lordship, I have one apprehension, Your Lordship. There's an instance that the petitioner has resorted to locking the gate, Your Lordship.
Huh?
Locking the office,
You are in
gate of-
possession?
Yes, I'm in possession, but they disturb the normal functioning of the
Then
office.
whose case?
Your Lordship, and therefore the status quo has been granted as it is. Your Lordship.
Understood.
Yes, Your Lord, should,
All interim orders doesn't survive any further. Now, the fact is you are in possession.
yes, I'm in
You
position.
are in possession, exercise. If they don't do anything, move the authorities. You know what to do. Why should I say?
Oh, yeah.
With the above the instant petition stands disposed.
Lordship.
So Joshua, that recently a judgment has come from the Supreme Court, very interesting case with in the context of this case. It was a case where a person concerned, I think it was Bharat Petroleum, who was a lessee, and there was the other person who was the lessor. He wanted to evict him, so for which a proceedings was filed. And the matter went out, and there was a order being passed that this person needs to be evicted. The matter thereafter this person has been evicted. Thereafter, another suit was filed seeking for damages. The civil court, as well as I think the Allahabad High Court, if I'm not wrong, held that it was barred under Order 2, Rule 2, that you should have asked for damages. The Supreme Court said no. The second suit would lie because asking for recovery of possession and asking for damages are two different separate cause of action.
My lord.
3-4 days back, the judge.
Your Lordship, if the document that I submitted,
Oh,
if
you
it's,
take this.
it's not put on
Whatever
record.
you want.
Yeah.
I'm coming, huh?
Bless you, Lordship.
Yeah, it is my pension, Mr. Secretary, because no, no, share. Without disturbance.
Which item is going on? Which item is going on?
Item number 33, when it will take up?
It will take up after a break. The
Break.
5
Thank
minutes. 5 minutes. The item number kemana? Next one. Jangan tu jadi 7 tu time dulu ya.
Itu mekanisme lagi tuh. Iya, saya.
I think 370 is the Item numbers 10 to 11.
Your lordship.
The state respondent is on his feet in court number 1.
Lordship, I pray that this matter come on Friday, Thursday,
Thursday.
on Thursday.
Where is that order? At the request of the learned councils, the matter stands adjourned to be listed again on
Thursday.
7.
on 8th of December.
Obliged.
Please, Lordship.
Yes,
Lordship, I'm for responding to Lordship. Lordship, I'm yet to find my counter, Lordship. I'm yet to find my counter.
what are you challenging?
Your Lordship, the petitioner is convicted under Section 138 NI Act, Your Lordship, and he was sentenced to undergo imprisonment of 2 years.
It's come for admission.
Yes, Your Lordship.
It's not admitted yet. We're outside. Are you inside or outside?
Your lordship, no, he's not under custody.
Do you want we admit it? Call for the records?
Yes, your lordship.
Immediate order, impugn order 13/4/2022.
Your lordship, IA is yet to be heard, your lordship, for continuation of delay of 185 days.
So you are not sentenced. You are only sentence is to pay 15 lakhs.
Yes, your lordship.
Nothing more.
Yes, your lordship.
The instant revision application has been filed challenging the order dated 13/4, judgment dated 13/4/2022, whereby
Your
the
lordship, as well as 15/12/2022.
whereby the petitioner hearing was sentenced to pay a fine of rupees 15 lakh within 30 days from the said order. However, as the said order was not complied with, another order was passed on 15/12/2022. Whereby the petitioner was sentenced to undergo simple imprisonment for a period of 2 years from the date of passing of the order. It was, however, observed that the petitioner be released upon payment of the fine amount of rupees 15 lakhs. For the purpose of deciding the instant dispute, the instant revision application is required to be admitted. Accordingly, the revision application stands admitted and is fixed for hearing. The local records would also be required to be perused, for which the same be called for by the registry at the earliest. List the matter for hearing along with the lower court records immediately upon receipt of the lower court records.
Bless you, lordship.
Bless your lordship.
Yes, you want
Yes,
to
my
transfer
lord. Yes, my lord.
from where to where?
From Dimapur Principal District Judge to Kohima.
Why?
This is the nearest station for the parties, my lord, nearest court.
Can that be a reason?
My lord, the present district judge, you could not take up because the impugn order of he was the one who passed the impugn judgment order, my lord, which is under challenge in the first appeal.
Now,
Now he's still there as a principal district judge, my lord.
who passed the order?
My lord, by Inalo Zimomi, my lord.
Where is it?
My lord, it's at page 40, my lord, and extra H.
Inalu Jimomi.
my lord,
He passed the order.
my lord.
Now, who is the principal district judge there?
Inalu, same
Is
person,
it?
yes,
So you want the transfer?
yes, my lord.
The instant transfer application under section 24 of the Code of Civil Procedure 1908, for short the CPC, has been filed for transfer of first appeal number 1/2017, pending before the court of the principal district judge Dimapur, Nagaland, to the court of the district judge Kohima, Nagaland. It has been stated in the bar that the judgment and decree, which is the subject matter of challenge in first appeal number 1/2017, was passed by one Mr. Inalu Jimomi. Page 56, you will get the exact figure. Inalu Jimomi, who was then the civil judge, senior division at Dimapur. The said Mr. Inalu Jimomi is presently discharging the functions of the principal district judge, Dimapur, Nagaland, and as such, he cannot take up the matter for which the instant application has been filed. The legal counsels appearing on behalf of the petitioner have also submitted that there is an urgency in the matter for which the matter requires an early disposal. Taking into account the above, this court is of the opinion that this is a fit case for transfer of first appeal number 1/2017, which is pending before the principal district judge Dimapur, Nagaland, to the court of the district judge Kohima, Nagaland. Accordingly, this court therefore directs the principal district judge Dimapur, Nagaland, to forthwith, upon receipt of a copy of the instant order, to transmit the records to the court of the district judge Kohima, Nagaland. The parties are directed to appear before the court of the district judge Kohima, Nagaland on 19th of January 2024. The registry of this court is directed to ensure that the principal district judge, Dimapur, Nagaland, transmits the records to the court of the district judge, Kohima, Nagaland, on or before 15th of January 2024, so that the matter could be taken up by the court of the district judge, Kohima, on 19th of January 2024, as directed above. With the above, the instant application stands disposed.
I don't want to be.
Yes, who is appearing?
May I please, your lordship? Your lordship, I have instruction to withdraw this petition, your lordship.
Withdraw.
Yes, your lordship.
Your name?
Vitere.
Huh?
Vitere.
Yes. You are there? You have signed your wakalatnama?
Yes, your lordship. My name is.
So and so, the learned counsel appearing on behalf of the petitioner submits that she has instructions to withdraw the instant application. Accordingly, the instant application stands closed on withdrawal. No interim order.
No, your lordship. Your lordship.
I think
Yes, bail.
Yes, Lordship.
Why you have been convicted? Or
Yes,
what is it?
Lordship, here the
Bail in what case? Let us see.
one informant has filed an FIR under section 406, 417, and 420, Your Lordship, against the accused, Lordship, alleging that the accused has
Charge sheet they have done.
charge sheet is completed, Lordship.
Hmm?
Yes, Lordship.
Already charged.
And you have been inside
Yes, Lordship.
406, 417, 420.
Yes, Lordship.
And charge sheet under what provision? Where's the charge sheet?
Lordship. Finance. The accused has been shown arrest since 9/12/2022, Lordship. And since he has been in judicial custody for more than 300 days, Lordship.
For how long?
For more than 300 days, Lordship. He was shown arrest on 9/12/2022.
More than
More than 300 days, Lordship.
200,
300 days, Lordship.
300.
Yes. He was shown arrest on
9/12.
9/12/2022.
You are about to finish it, huh? 1 year.
Yes.
Yes, why you have not been released?
Lordship, the accused has approached the Dimapur District Court, Lordship, for bail, but however, this bail was rejected, Lordship.
Hmm? Yes, PP, what do you have to say?
Lordship, since it has already been charged sheeted and Lordship, since that is the only instruction that I received. And since on the last occasion, this honorable court has called for the lower court case there, Lordship. And that is still.
He has already been charge sheeted.
Yes.
This is some 406, 417, 420.
Yes.
So I think he can be released.
Lordship.
No point keeping him inside.
Lordship.
Let him enjoy Christmas.
If I may be allowed to place, Lordship, his medical record, Lordship. Yes.
Not necessary. The instant application is filed under section 439 of the Code of Criminal Procedure 1973 for grant of regular bail to the petitioner who was arrested on 9/12/2022 in connection with Dimapur East Police Station case number 0125/2019 under sections 406/417/420 of the Indian Penal Code. This code also finds it relevant to take note of that pursuant to the FIR being lodged on 9/5/2019, the charge sheet has been submitted, being charge sheet number 130/2020 on 26/12/2020. Taking into account that the investigation is already over, Who has filed this? Jacob Lee.
The company, yes.
Who is the petitioner?
Manindra Kakoti,
And Jacob Lee.
yes. Oh, Jacob.
This court finds no reasons as to why the petitioner herein, why there should be further detention of the petitioner during the process of the trial, inquiry and trial. Accordingly, this court grants the regular bail to the petitioner. Subject to the following conditions. বাকি এটা ফৰ্মেট এটা আছে নহয়, সেই ফৰ্মেটত ভৰাই দিব। Amongst the 4-5 conditions are there. One condition will be the petitioner shall appear before the court in the of the Chief Judicial Magistrate Dimapur, Nagaland, on each and every day when GR case number 363/2019 is fixed by the court. The petitioner, in case the petitioner, for reasons beyond his control, is not in a position to appear, his counsel, who represents the petitioner in the said proceedings, shall duly apprise the learned trial court the reasons for his non-appearance. And how much? What do you do? What do you do?
Lordship.
What do you do?
Oh, Lordship, businessman, Lordship. Businessman, Lordship.
50,000. Bill one.
Oblige, Lordship.
Security.
Lordship, I have a similar prayer with item number 32, Lordship, which is,
Huh?
I have similar prayer in item number 32, Lordship, which is in order in supplementary cost list. Same accused, Lordship. However, here the LCR is still awaited, Lordship.
Wait.
Okay.
This is item number?
32, item 32.
This is 32?
This is 30.
30.
Yes.
Let us have it
Okay.
serially. Wait. Other lawyers may mind jumping.
Lordship.
Yes.
Oblige, Lord.
Orders, item number 15.
May I please, Your Lordship?
Yes, this is
Lordship.
for what?
This is for appointment of an arbitrator, Your Lordship.
Appointment of an arbitrator.
Yes, Your
Who is
Lordship.
appearing?
Lordship, I'm appearing on behalf of SKMD.
What about the other side?
Await service report, Your Lordship.
Await service report.
Yes, Your Lordship. Step was taken on 7.
None appears on behalf, as already released the matter on so and so.
Your Lordship, let them let it
Where is
be.
that? Service on him. Because again, the problem will arise, no? Where is the arbitration? Where's the office notes? What is the office note? No, what is happening? Office note. Whether service is complete or not. Maybe. We have it next week. Yeah. Awaiting reply when he is unable to listen to it. But list the matter again on
19 January, Your Lordship. 19 January.
no, wait. List the matter again on 8th of December 2023, on which date the registry shall indicate as regards the as to whether the service has been duly effected upon the respondents. We'll see on that day.
Yes, sir.
And
Okay.
thereafter, if you want, we'll repeat it in January, February, whichever you like.
God bless.
Item number 16.
Same.
Similar, yes, Your Lordship.
Same.
Item number 18.
May I please, Your Lordship?
Ah.
Your Lordship, we have been approached by the respondent to represent them, and we have received a copy only this morning.
Notice issued to so and so with ADMS returns. Okay.
Lordship, we are yet to file the Vaklat
The
namas.
registry shall list the matter again on 8th of December 2023, giving an update as regards the service upon the respondents.
Oblige, Your Lordship.
And see, because this is office notice of 1511. So let's see what has happened in the meantime. Okay? 8.
Your Lordship.
For orders, item number 19.
Yeah, please, Your Lordship.
Hmm.
Lordship, as per office note dated 7/11/23, away service report. Upon all the respondents. Yes, Your Lordship.
Has notice been issued?
Yes, Your Lordship.
Then what happened? The registry is directed to again list the matter on 9th of December 2023. Not 9. On 11th of December 2023, giving an update as to the status of the service upon the respondents.
God bless.
For orders, item number 20.
Yes. What is this? Why the matter has been listed? Huh? Huh? Why the matter is listed today? Who is appearing?
I didn't do this for hearing.
This is item?
I didn't do this for hearing.
No, this item is item number what? This is item?
31. For orders.
For orders, 31. Yes.
May it please your Lordship.
Yes.
Lordship, this matter is with regard to compassionate appointment and
this
the
for
contempt of
The
petition.
contempt proceedings.
Yes, Lordship.
Who is appearing?
Lordship, I am appearing on behalf of petitioner.
Petitioner. Respondents who are appearing. Contempt. What is your stand? Respondent? What was the direction? Now, you have to consider whether you give or not is your lookout.
Lordship.
Now, what is your stand?
So, our stand is that Lordship. Now the petitioner,
Somebody has filed you have filed your affidavit.
no Lordship.
File your affidavit.
Lordship,
Yes,
I have also filed an additional affidavit.
Yes, I've seen it.
Yes, Lordship.
Yeah, what is it?
Lordship, as per the office memorandum dated 17 September 2015,
Appointment shall be made on regular basis to the direct recruitment post who die in harness.
the compassionate appointment should be on regular basis, and in the year it should not be exceeding 50%.
Now, anyways, this is your affidavit we have taken on. Yes, Mr. Counsel, you file your reply. When?
After vacation.
Why after vacation?
Lord.
After vacation, this is a matter pending since when? Contempt is to be urgently taken up. What do you say?
Yes, Lordship.
Huh?
Yes, Lordship. In 2022, Lordship.
Okay. File your affidavit by 14th December.
I will be avering for
No, whoever it is, Mr. Counsel, you are to file your affidavit on or before. I'm taking up on 14th of December. File your affidavit by 13th.
Lordship, I will be avering for respondent number 1 in fact.
Whoever it is your thing. 1, 2, whoever it is. You see, there was a direction out here directing the chief engineer in chief PWD respond number 2. Now, what has he done? Who is appearing? Engineer in chief, the NPDW. I think this is number 2.
I'm appearing for 2, 3, and 4.
Okay, you file your affidavit.
No.
And what does the commissioner and secretary have to do? You are appearing.
I'm appearing.
Okay.
Lordship,
The council appearing for respond number 2, 3, and 4 shall ensure that the affidavit of the said respondents are filed by 13th of December 2023. List the matter on 14th of December 2023.
Published.
You file your affidavit, say whether you have considered or not. If you have not considered, then Christmas in jail, otherwise, yeah.
Lordship, here, the same accused, Lordship. Here it has been shown arrest on 7/12/2022, Lordship. It's more than 3 days, 300 days, Lordship. However, LCR is still awaited, Lordship. We have filed,
What has happened? The same accused, same case? No.
allegations is of somewhat of the similar nature, Lordship. Similar nature, Lordship, allegation.
Similar nature is different. Same case. Who has been granted bail here? 437, 26/9/6/2023. Who has been granted bail? Accused person, namely Manindo Kandi, is going to be given to the. Here, what is the status of the investigation?
Completed, Lordship.
Huh?
Completed. Charge sheet has been.
Where is the charge sheet?
Charge sheet. They have not annexed the charge sheet.
Yes, Lordship.
You have it? You have the charge sheet?
Charge sheet in the earlier bill application, they have annexed.
There is the same charge sheet. He can't be arrested for twice in respect to the same case.
Lordship.
Isn't it the same person, Jacob Lee?
Lordship.
Yes, Lordship.
Same accused.
Same accused.
Yeah. When were you arrested?
7/12/2022, Lordship.
And this is under what section?
406 and 420 of IPC, Lordship.
Okay, we'll have it on Friday or Thursday. Get hold of a copy of the charge sheet.
Lordship, this is the same charge sheet they have annexed in the earlier bill application.
But that charge sheet is in respect to some other case.
Yes, Lordship.
How can
Here
that
the-
be the same? Because that is of some 125 or what is the number of the charge sheet? The case number FIR? Hey, can you give me that case, item number 30? 30, na? Yeah,
yes,
earlier
30
matter was
yes,
what?
30, Your Lordship. So, in the previous, the informant is different here, the another informant is different, Your Lordship. Informant is different, Your Lordship.
Informant is different. Informant as could be seen, has been arrested in many cases.
Yes, Lord.
This is for this East, Dimapur East, PSK 125, 406, 417, 420. And this FIR has been, the charge sheet is different. How can we say that it is the same charge sheet?
Different, Lordship.
Then it can't be done. List the matter again on 8th of December 2023, on which date Mr. So-and-so, the learned PP, shall ensure that to ensure as to whether shall apprise this court as to whether any charge sheet has been filed in respect to the instant case, and if so filed, produce a copy of the said charge sheet.
Okay. Right. Oblige, my lord.
Case number to Lekiri. Any more matters? How many?
Yes, minutes. There is item 32 and 33 minutes. 33 and 34 minutes.
What is that?
Minutes. This is a petition being filed by me, minutes, with regards to questioning of the summoning order in 138 matter. So, minutes, the affidavit in reply has been received today, this morning by me.
Mr. Counsel, why do I need an affidavit for that? Those type of matters.
Yes, minutes, but they have filed, this court
You
was
file
three.
an affidavit, we will file. Where is the question of filing affidavit or replies in such matters? The only thing we have to look into it as to whether the case, any case is made out.
I bow down, minutes.
Yeah.
So I can.
We'll do it, we'll take it up at 2. Other matters, I'll take it up at 2. Okay.
Yes,
Sure.
minutes. Grateful, minutes. On 18 December, 8 December. I think we need to have a was this I'll be this. And it's not money.
How many minutes are left? 3 minutes. 3 minutes. Tamamladı mı hocam? Supplementary bir şey daha değil. 너도 프레임으로 일단 하나 저거 그러고 막 그러지. Itu advocate lanam jane. Itu. Ayo na. Itu. Mana tam cost list mention karena itu. Itu dah ada itu kuna so. Itulah next tracking itu. Itulah next tracking itu. Apa beli dikit sih? Itu dari kita stop nama nasi nih saya pakai itu loh. Kalau nama itu kayak. Vehicle ada ya, nah, cica. Vehicle. Or 15 and 16. Cica. Green. Yellow. For orders, item number 33.
Who is appearing for the petitioner?
Lordship, the counsel for the petitioner appearing through VC. I
Very.
think there's some issue with a.
Picks up the vacation, no?
For hearing item number 20.
After vacation? What is the order passed? What is this matter about? Maybe 33 is this. 33 and 34. This one not after vacation? No, I've not signed. I've signed all the other orders. There's somebody who appeared in this matter.
Yes.
Just before me rising.
Yes.
So that's not.
Yes, 33 and 34.
These are not after vacation. Yes. Yes, Mr. Counsel. I
Yes.
can't hear you. Yes.
May I please, my lord? So this is item 33 and 34, my lords. If my lords may kindly take item 33. Now, my lords, this is a case where the complainant.
Tell me.
Yes, my lords. So this is a case, my lords, where the complainant himself, as per the affidavit and the documents which he has placed on record, is a resident of New Delhi and Noida, my lords, the suburb of Delhi. Now, my lords, there has been some business relationship and transaction, my lords, by and between the parties. The petitioners before my lords as of today are 3 persons. One is a partnership concern, that is Parth Project. Number 2 is Lords Major Vikas Chhillar, who is the one of the partner of the Parth Project, and Mrs. Sonam Singh, who is wife of Major Vikas Chhillar and also partner of Parth Projects. Now, my lords, what has happened that on account of the business relationship turning sour, in 2020 itself, I have issued a legal notice, which is on the record, my lords, and that notice has also been replied, whereby I have asked them not to deposit the checks because I had an apprehension that certain checks were missing from my place. But be that as it may, my lords, he proceeds to present first check out of 5 checks before concerned bank at Yes Bank, New Delhi, in Rohini. That check got bounced upon presentation. The complainant issues me a legal notice under section 138. I reply to that legal notice, my lords, and thereafter the complainant opt not to file complaint case under section 138 before the jurisdictional court at New Delhi. Now, my lords, thereafter, he traveled altogether to Paren at Nagaland from New Delhi, my lords. He opens a bank account. He presents one of the check, my lords, and then he get it bounced. He purportedly issued me a legal notice, my lords, and then he proceeds to file a complaint. Now, my lords, what is interesting is this, that, my lords, in terms of section 138 of the Negotiable Instrument Act, my lords, any offense under section 138 would only be deemed to be commenced upon receipt of the legal mandatory and a statutory legal notice. Here, the admitted case, my lords, as per the complaint which is being filed before the learned trial court, is this, that he has sent a notice, but since he did not have my correct address, therefore notice could not have been served. In this regard, my lords may kindly see the complaint starts at page 60 of the paper book.
Yes.
Now, my lords, if my lords may come to page 68, para 17 of the complaint.
Yes.
Thus, the complainant through its counsel issued a statutory legal notice dated 2nd March 2023, which was sent on 3rd March 2023 by speed post, thereby calling upon the accused person to pay the aforesaid check amount within 15 days from issuance of the aforesaid notice. However, despite mentioning the last known address of the accused person in above said legal notice, the same was returned on account of address being inaccurate. It is pertinent to mention that even after the best endeavor of the complainant, the current address of accused persons could not be traced. Therefore, complainant is constrained to prefer the present complaint before this honorable court. Now, my lords, this particular submission before the learned trial court that he did not have my address, it stands defeated by bare perusal of certain documents, which my lords would see. The legal notice, my lords may kindly see page 133. No. I'm so sorry, my lords. If my lords may kindly see the tracking report, the purported legal notice which has been...
No, Mr. Counsel. He had deposited the check and the return memo came to him on 8/2/2023. Thereafter,
yes,
it is that he had issued the check on 2/3/2023. That is his case, complainant.
Yes, ma'am. Yes, ma'am.
And it was returned on the ground that of insufficient address or whatever may be.
Yes, ma'am.
So your case is, as it is an admitted fact that the check could not be issued, the notice was not issued. The initiation of the proceedings under 138 could not have been made.
Yes, my lords. This is what exactly, my lords, I'm so grateful, my lords. This is what exactly section 138B stipulates.
Negotiable instruments.
Now, my lords, I can also show for my lord's consideration with regards to earlier round of notices exchanged between the parties, wherein the correct address is being known by the complainant. Even my email address, my mobile number, everything is mentioned in their own document.
And what is the other case?
Same matter, my lords. Same matter, but there, what has happened, my lords, that second complaint was filed before the learned trial court at Perin after a gap of 5 months. So, a purposeful fraud have been played before the learned trial court. Here, the admitted position is that he has written on a complaint on affidavit that it was not traced. There he is not writing that. He has realized by that time that he would have made a mistake, but he has annexed the tracking report, which I would show to this honorable court, which says, as per the tracking report exhibited before the learned trial court, that the consignment of that legal notice has been received back to the sender itself. Now, if my lords has a negotiable instrument act,
Just 1 minute.
yes, my lords.
What's your copy of the act?
Yes, 138.
So I will just use the pilots this proviso, provided that nothing contained in this section shall apply unless A, the check has been presented to the bank within a period of 6 months from the date on which it is drawn or within the period of its validity, whichever is earlier. B, the payee or the holder in due course of the check, as the case may be, makes a demand for payment of said amount of money by giving a notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the check as unpaid. And C, the drawer of such check fails to make the payment of the said amount of money to the payee or, as the case may be, to the holder in due course of the check within 15 days of the receipt of the said notice. Now, my lords, in my
So, when
respectful
it is an
submission,
admitted case that the check, that the notice was not received, then
lords.
by virtue of the proviso C,
My lords,
the initiation of proceedings could not have happened.
my lords, that's substantive of my submission, my lords.
Who is appearing for the respondent?
I'm appealing for the respondent, Lordship.
Yes, tell me, how do you take care of that?
Lordship, in the first place, Lordship, by filing the present petition, Lordship, a prayer is made for quashing of the criminal prosecution, Lordship. Lordship knows, I have filed the affidavit, Lordship, this morning, Lordship. Now, there are 5 acts which has to be committed, Lordship, as far as the section 138 is concerned, Lordship. Now, all the 5 acts, Lordship, it has been made out in my complaint petition, Lordship. And the petition has enclosed my complete petition at page 60, starts from page 60, Lordship. Now, a check was presented to me, Lordship. It was handed over to me. I have presented the check on the 4th of February, Lordship. And a memo was issued on the 8th of February, Lordship. Now, on the 2nd of March 2023, I've issued a legal notice and I have enclosed all the tracking, Lordship.
But
now,
the fact that the legal notice was not served, if there is no receipt, could you have initiated the proceedings?
Lordship, I have enclosed all the tracking record, Lordship, of the notice, Lordship, in my complaint petition.
No, that's your admitted statement,
Lordship.
In paragraph number 17.
If your Lordship may kindly appreciate, Lordship, cognizance was taken by the trial court, Lordship. Lordship, if your Lordship may kindly refer to the orders or...
Yes, page, this order at page... we are concerned with 17.5 order.
17.5, Lordship. And thereafter, Lordship, subsequent orders were also passed.
No, I'm not concerned with subsequent order. It was 17.5 order.
17.5.
Where cognizance was taken.
Lordship.
But the fact that if he has not received the check and notice, would you have initiated the proceedings under 138?
Lordship, the law is very clear as far as the notice is concerned, Lordship. As far as the notice to the accused person is concerned, the law is very clear, Lordship. If I may be allowed to rely on some decisions, Lordship. I finished the 2007-6 SSC, page 555, Lordship.
You're given the list of books?
Yes, Lordship. 2007-6 SSC, page 555, Lordship.
Okay. Yes.
If your Lordship got it. May I start from paragraph 7, Lordship? The issue with regard, if your Lordship got it, may I read it, Lordship?
Yes, yes.
The issue with regard to interpretation of the expression giving of notice used in clause B of the proviso is no more res integra. In so-and-so case, the said expression came up for interpretation. Considering the question with particular reference to scheme of section 138 of the Act, it was held that failure on the part of the drawer to pay
amount should be within 15 days of the receipt of the said notice. Giving notice in the context is not the same as receipt of notice. Giving is a process of which receipt is the accomplishment. It is for the payee to perform the former process by sending the notice to the drawer at the correct address and for the drawer to comply to clause C of the proviso. Emphasizing that the provisions contained in section 138 of the Act required to be construed liberally, it was observed thus. Para 20, Lordship. If a strict interpretation is given that the drawer should have actually received a notice for the period of 15 days to start running, no matter that the payee sent a notice to the correct address as trickster, check drawer would get the premium to avoid receiving the notice by different strategies, and he could escape from the legal consequences of section 138 of the Act. It must be borne in mind that the court should not adopt an interpretation which helps a dishonest evader and claims an honest pay, as that would defeat the very legislation measure. Para 21. In Maxwell's interpretation of statutes, the learned author has emphasized that provisions relating to giving of notice often receive liberal interpretation. The context envisaged in section 138 of the Act invites a liberal interpretation for the person who has the statutory obligation to give notice because he is presumed to be the loser in the transaction, and it is for his interest the very provision is made by the legislature. The words in clause B of the proviso in section 138 of the Act shows that the payee has the statutory obligation to make a demand by giving notice. The thrust in the clause is on the need to make a demand. It is only the mode for making such demand which the legislature has prescribed. A payee can send a notice for doing his part for giving the notice. Once it is dispatched, his part is over. This is a very clear, Lordship. And the next depends on what the sendee does. Para 8. Since in so case, the notice issued in terms of clause B had been returned unclaimed and not as refused, the court posed the question, will there be any significant difference between the two so far as the presumption of service is concerned? It was observed that though section 138 of the Act does not require that the notice should be given only by post, yet in a case where the sender has dispatched the notice by post with correct address written on it, the principle incorporated in section 27 of the General Clauses Act 1897 could profitably be imported in such a case. It was held that in this situation, service of notice is deemed to have been effected on the sendee unless it proves that it was not really served and that he was not responsible for such non-service. 9. All these aspects have been enlightened and reiterated by this court recently in Vinod's so-and-so case, elaborately dealing with the situation where the notice could not be served on the addressee for one or other reason, such as his non-availability at the time of delivery, or premises remaining blocked on account of his having none gone elsewhere. It was observed that if in each such case, the law is understood to mean that there has been no service of notice, it would completely defeat the very purpose of the Act. It would then be very easy for an unscrupulous and dishonest drawer of a check to make himself scarf for some time after issuing the check so that the requisite statutory notice can never be served upon him, and consequently he can never be prosecuted. It was further observed that once the payee of the check issues notice to the drawer of the check, the course of action to file a complaint arises on the expiry of the period prescribed for payment by the drawer of the check. If he does not file a complaint within 1 month of the date on which the course of action arises under clause C of the proviso to section 138 of the Act, his complaint gets barred by time. Thus, a person who can dodge the postman for about a month or two, or a person who can get a fact endorsement made regarding his non-availability, can successfully avoid his prosecution because the payee is bound to issue notice to him within a period of 30 days from the date of receipt of information from the bank regarding the return of the check as unpaid. He is therefore bound to issue the notice, which may be returned with an endorsement that the address is not available in the given address. This court held under so-and-so. 15. We cannot also lose sight of the fact that the drawer may be dubious means managed to get an incorrect endorsement made on the envelope that the premises has been found locked or the addressee was not available at the time when postman went for delivery of the letter. It may be that the address is correct and even the address is available, but a wrong endorsement is manipulated by the address. In such a case, if the facts are proved, it may amount to refusal of the notice. If the complainant is able to prove that the drawer of the check knew about the notice, and deliberately evaded service and got a false endorsement made only to defeat this process of law, the court shall presume service of notice. This, however, is a matter of evidence and proof, Lordship. This is important. Thus, even in a case where a notice is returned with the endorsement that a premises has always been found locked or the addressee was not available at the time of postal delivery, it will be open to the complainant the proof at the trial by evidence, Lordship. This is also important, Lordship. It can be proved at the time of trial. That endorsement is not correct and the addressee, namely the drawer of the check with knowledge of the notice, has deliberately avoided the received notice. Therefore, it will be premature at the stage, this is for the Lordship, to issue process to move the High Court for quashing of the proceeding under Section 482 of the Code of Criminal Procedure. The question as to whether the service of notice has been fraudulently refused by unscrupulous means is a question of fact to be decided, Lordship, on the basis of evidence, Lordship. Only on the basis of evidence. In such a case, the High Court ought not to exercise its jurisdiction under Section 482 of the Code of Criminal Procedure. This is very clear, Lordship. It is thus tried to say that where the payee dispatches the notice by registered post with correct address of the drawer of the check, the principle incorporated in Section 27 of the CG Act would be attracted. The requirement of Clause B of the proviso of Section 138 of the Act stands complied with, and the cause of action to file a complaint arises on the expiry of the period prescribed in Clause C of the said proviso for payment of the drawer of the check. Nevertheless, it would be without prejudice to the right of the drawer to show that he had no knowledge that the notice was brought to his address. However, the referring bench was of the view that this court in so did not take note of Section 1114 of the Evidence Act in its proper perspective. It felt that the presumption under Section 114 of the Evidence Act being a rebutted presumption, the complainant should contain necessary averments to raise the presumption of service of notice, that it was not sufficient for a complainant to state that a notice was sent by the registered post and that the notice was returned with endorsement out of station. Therefore, the moot question requiring consideration is in regard to the implication of Section 114 of the Evidence Act, insofar as the service of notice under the said proviso is concerned. Section 114 of the Evidence Act reads as under. Court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct in public and private business in their relation to the facts of the particular case. This is very clear, Lordship.
Then, so as per you, these are questions of facts which the trial court will look.
Exactly, Lordship. Exactly, Lordship. And it is premature at this pre-trial stage, Lordship. And by this criminal petition, Lordship, several question of facts has been raised. Disputed question of facts has been raised.
Those don't worry, I'm not looking into all those things.
And Section 139 presumption is in my favor, Lordship. 139 of the Act, Lordship.
Yes, Mr. Counsel, what is your next submission?
Yes, my lord. So substratum of the judgment being cited by my learned friend basically provides for three things, my lords, in my respectful submission. One is that the drawer of the check has sent the notice on the correct address. That's very important, my lords, which I will show something.
Now, this, Mr. Counsel, this court is not going to look into as to whether it has been done in a correct address. This is a question to be shown out there in the trial court.
My lords, my respectful submission, my lords, I will ask a question to myself.
On the question of law.
I will just make one submission, my lords. My lords, if I have to file a case, my lords, and I'm asking this question to myself, my lords, and I deliberately write the wrong address, my lords, deliberately, and then I come to then I defend the quashing petition on the ground that this is an issue of fact which has to be dealt by the trial court, my lords, in my respectful submission, that would be travesty of justice. Why I say this, my lords, if my lords may kindly see just 2-3 pages, which will show everything. My lords may kindly see page 79, that is a purported legal notice, which my learned friend was referring to. Now, my lords may kindly see 2 and 3. My lords will see just below the address, there is an email address, my lords, and there is a mobile number.
Just 1 minute.
my lords.
Tell me.
My lords may kindly see, this is a legal notice in question, which is CW 1/3 exhibited. My lords may kindly see addressee number 2 and 3. My lords will find that email address, mobile number of both the persons have been mentioned, my lords. They have not taken any step of service by email or by WhatsApp, my lords, and earlier emails have been exchanged between the parties.
That is not necessary. Whether this notice has gone out there in this address, and these are the two, these addresses are flat number A 702 NX Society.
My lords may kindly see that address itself is wrong, number one. Number two, my lords, says the fact is this, that if they want to benefit out of the presumption, they ought to have exhibited before the learned trial court the return envelope. Whenever the envelope is returned back to the sender by the consignee refusing the notice or left.
The counsel, these are the things which this court is not going to look into it.
Lords, in my respectful submission.
No, Mr. Counsel, no.
One judgment.
Secondly, as regards, you are appearing for petition number 1?
Yes, my lords.
Are you appearing for petition number 1?
Yes, my lords.
The petition
No, I'm not admitting the notice to be served, my lords. No address, no notice has been served for 1, 2, and 3.
It has been served or not is a question which can be seen in the trial court.
My respectful submission today, which
stated by the Supreme Court.
My lords may kindly appreciate one point, my lords. Only one. The second aspect, if my lords may kindly see the tracking report itself. Now, my lords, this is a mischief how it has been played. A person who has an address of New Delhi, a person who has presented first check in New Delhi, issued 138 notice. I reply back to that legal notice. He opt not to file the complaint before New Delhi. In order to harass me, my lords, he goes all together to Nagaland and to file. And then, my lords, he did not serve a legal notice to me. And, my lords, he proceeds to file a complaint. Now, my lords, may kindly connect these dots, my lords. I would beseech this honorable court. This is not a standard matter, my lords. Why I say so? If my lords may kindly see the tracking report, which was exhibited before the learned trial court as page 93. Page 93 is the starts of the paper book, my lords, and my lords may kindly come to page 94. Page 94, my lords may kindly see from the top, 7th, item returned insufficient address. Now, my lords, when the complainant itself deliberately is not sending the legal notice to the correct.
This is for whom?
My lords, this is for to the noticee, my lords, since the tracking report and the return envelope have not been annexed purposely by my learned friend's client before the trial court, my lords. So I have this just from the trial court records. Postal receipts are also not there, my lords. May kindly see when the address is insufficient, my lords. Now, if my learned friend's client would have sent a legal notice only in the name of Miss Sonam Singh, Pune, Maharashtra, my lords, in no sense it would be termed at service. In order to draw the benefit of General Clauses Act, my lords, he ought to have exhibited the return envelope. Now, my lords, if the return envelope would have been exhibited before the learned trial court, it would have shown my complete address, my lords. The presumption would have gone into his favor, my lords. But here the presumption is in my favor, my lords, due to the statutory embargo as provided under section 138. Even the substratum of the judgment which my learned friend was referring to says, my lords, correct address. I emphasize, my lords, it's the judgment says correct address. Even in K. Bhaskaran, my lords, there is a Supreme Court judgment, if I may rely upon, my lords. This is K. Bhaskaran versus Sankaran Vidyan Balan, Milos SCC online, Milots. I will just give the citation. I will just read, Milots, what the Supreme Court says with regards to correct address.
Where? Give the citation.
Yes, Milots, the citation, it's Milots SCC 512-1999-7.
What is that? What type of citation? Which year? Of which year?
Yes, Milots,
What is the citation?
Yes, Milots, it is of 1999, 7 SCC.
Yes, then?
Milots, here,
Page?
Milots, may kindly come to page 512.
What is the page, Mr. Counsel?
Page 512, Milots.
512 is the citation.
Page, Milots, the internal page would be, Milots, may kindly.
1997, 99, 7
9.
page.
Milots, from the book, it should be 512. From the SCC book, Milots. And from the.
But there is no 512. That can be 510.
Milots, I have an online edition, Milots.
Online or whatever may be, the citation will be, see in the first page.
Yeah, Milots. I'm here, Milots, on the first page itself. SCC, Milots, it is, if Milots may kindly see.
Oh, if you can't rely, show me, give the citation, then why should I rely on that? You do in the Supreme Court. Let me dismiss this.
I'm just finding out the citation.
You are not here with this matter.
Only one submission, Milord.
Mr. Counsel, go to the Supreme Court. I'm dismissing it right away on this ground. You are not in a position even to say what is the citation. It's only.
I'm so sorry. There is some.
What is wrong?
Online edition.
You don't know the citation.
No,
what is the citation of the year? I'm asking you, 1997 SSD. What is the page? There's no 1997 SSD 510.
Any page, Milord, from my online record, it says, Milord, the judgment starts at page 521. Citation.
521. There's no 521 in 1997 SCC.
Kindly see 510.
Ah, there is 510. Can't you say that? That is the same thing what I am asking you.
I'm so sorry, Milord.
What's the manner in which you place citations?
Electronic version, Milord. I'm so sorry for this.
No electronic version of that. Yes, tell me. This is the judgment which has been taken note of by the Supreme Court in Alba Haji.
Milords may kindly see the running page 512. Now, Milords, the head note with regards to B, if Milords will see Negotiable Instrument Act 1881.
Counsel, this court doesn't have the habit of going through the head notes. Show me which is the relevant paragraph. Head notes are written by whom? It is done by the editor. Editor doesn't. Kindly show me which is the paragraph you are relying upon.
Milords may kindly see page 513.
513 again, these are all head notes.
Do Milords, I will come to the finding, Milords.
You come to the finding of the paragraph which is there. Don't come to show me all this head note business and all.
Milords said page 513, if Milords would see, if in sub B, Milords, if a strict interpretation is given that the drawer should have actually received a notice for the period of 15 days to start running.
Counsel, do I have to again remind you? This is a head notes. Kindly come to paragraph 20. Or is it the habit out here that you look into only the head notes and not the judgment?
No, my lords, my only submission was what my lords.
Take a cue from your opposing counsel. You were shown paragraphs from the judgment, not from the head notes.
No, my lords, I only.
Up to paragraph 20, which you are referring to. Page
Para 20,
59.
my lords, if a strict interpretation is given that the drawer should have actually received the notice for the period of 15 days to start running, no matter that the pay sent the notice on the correct address. Now, my lords, I emphasize on the word correct address, my lords. Now, my lords,
this has been what has been also stated by this paragraph has been duly shown by the learned counsel for the opposing counsel. This was the paragraph which was relied upon in this Al-Wahazi.
My lords, that I only emphasize on the word correct address. If my lords allow me to show
correct or not, you have an opportunity to show it before the court. That is what the Supreme Court has stated.
No, my lords, that's the mischief, my lords, being played. Now, my lords, the complainant is of Delhi.
Going to look into those mischief or whatever may be. That is for the court, for those courts to look into.
My lords today would see, my lords, that the complaint, if my lords may kindly see one aspect, if my lords would see the complaint at page 61. And the memo of parties.
Yes.
The complainant name is Balaji Enterprises, true proprietor, Mr. Kumar Rajesh, A121 DUG apartment, Rohini, New Delhi, my lords. And all the form, these are of New Delhi or Maharashtra, my lords. The complainant has no business whatever, my lords. Just for the purpose of harassing a person to travel altogether to Nagaland, my lords, a bank account is being opened, my lords. And the bank account is opened, a notice is purposely not being sent, my lords. These issues, my lords, in my respectful submission, this court being a constitutional court, my lords, will appreciate this.
This court is not sitting under 226. This
My lords,
court is sitting under 482.
my lords, my respectful submission, my lords, that while exercising any jurisdiction, my lords, this court is not bereft of the power.
Are you saying that as per even the judgment which you are relying upon, there is no jurisdiction which vests upon the court wherein, in respect where the check has been bounced? As there are 5 places where you had the jurisdiction, and of which one happens to be a place where the check got bounced. Was submit presented? If that is the jurisdiction, then obviously,
you need
to ask the Supreme Court to reconsider the judgment.
May I then in that event, my lords may only give me 2 days time to file a compilation of judgment to substantiate my point of view, my lords. Just 2-3 days, my lords may kindly give.
You don't have a compilation. I have not even asked you what is you are to show me the judgment.
I only received the affidavit in reply.
First, Mr. Counsel, show me what happened to the judgment in K. Bhaskaran, which has been referred and the large bench has decided. Are you aware of that?
There are subsequent judgments as well, my lords, wherein Honorable Bombay High Court.
Forget about Bombay High Court. I'm asking you. The current judgment went to the Supreme Court, was referred to a larger bench. Are you aware of that?
No, my lords, I'm not. I'm so sorry.
Without being aware of that, you are trying to impress upon the court to take up a matter in this manner.
I am so sorry, my lords. May kindly give me 2-3 days.
A very sorry state of affairs.
I'm so sorry, my lords. Kindly give me 2-3 days.
No, I'm sitting out here after a long time in Kohima. Does it work in this manner that you don't know and you file matters out here?
Lords, I will, lords, just give me 2. I just pray for 2 days time, my lords. May kindly list it after 2 days, my lords. Let me work out on all the compilation and file it for them.
There's the matter on 7th for further hearing.
Grateful, my lords. Obliged. Grateful, my lords. Obliged.
The counsel, whatever your judgments which are there, just give a note to these people. Lord, okay?
I will do it.
And you also by tomorrow ask your people to do it by tomorrow or day after.
Grateful, my lords. Obliged.
For hearing item number 20.
Lordship, your lordship, in this case, I'm saying that I have acted as per the rules. As per the rules, administration rules for the administration of justice and police in Nagaland, 1937 rules. My friend is saying no.
However, so called advice the impugned judgment passed by the PA to the DC should not be. PA to the DC can pass.
Lordship under, Lordship. For administration.
There is some judgment, no?
Lordship,
PA to the DC cannot.
Division bench has already settled this issue, issue which is involved in this case.
Then, where's the judgment?
It's here. Lordship.
We close it on that aspect.
Yes, Lordship. Lordship, under Rule 23, the Deputy Commissioner, he can endorse the matter to the Purchase Court for trial, not for appeal. In the present case, the Deputy Commissioner has endorsed the file to the Deputy Commissioner to sit on appeal against the order passed by the.
Where is that order? Impugned order?
The impugned order is at page number.
Where is the, yeah. The PA to the DC has signed it.
Yes, page 26.
I think what we do, we set aside this and ask the DC to do it.
He can dig up the matter, but he can, the Deputy Commissioner, he can dig up the matter, but he cannot endorse the case to the Toboshi court.
To the
DB's court.
Whether he does or not, that is a subsequent action. First, the PA to the DC couldn't pass the order.
He cannot pass any order.
So why should I foreclose you from coming again to the court and lose your revenue?
From the impugned order also, it is very clear that the Deputy Commissioner has endorsed the matter to the DB's court. And Lordship, under Rule 23. Just
the division bench judgment like that. We follow the division bench, set aside this and ask the Deputy Commissioner to take that. That is the fair thing.
But Lordship, the problem is, Lordship, the counsel for the private respondent is not present today.
Who?
Counsel for the respondent, private respondent.
So, if he is not, his name is shown in the cause list?
Yes, shown in the cause list.
Fantastic. So, I'll record it.
If he comes also, he don't make it.
In spite of asking the council, in spite of his name being duly shown, he has not appeared.
It's his own risks.
No, I'm not foreclosing his right altogether.
Yes.
When a PA to the DC cannot pass an order, so matter goes. So let the Deputy Commissioner take a call. Because there was a stay must be. This order. The instant, what is this, 227 or 115? The instant proceedings under section 115 of the Code of Civil Procedure 1908, read with Rule 32 of the Rules of Administration of Justice and Police in Nagaland 1937. Bracket Third Amendment Act 1984 is filed, challenging the order dated 2010-2020 passed by the personal assistant,
political assistant,
bracket PA, to the Deputy Commissioner Twensang in respect to a land dispute case located at 3rd NAP Sakshi sector, main gate area. Full stop.
This appeal was taken up against the order, the order dated 21, page number 21. This is
We are concerned with 2010-2020.
Yes, Lordship, but this was passed on appeal. The original order is at page 21. This is passed by the GB's court.
No, as per your rules of administration of justice, the matter can be very well filed, an appeal lies to the Deputy Commissioner.
Deputy Commissioner.
And once the Deputy Commissioner has to decide that, either he may decide it on the basis of what the judgment without following anything, but if he wants to decide anything, or he may sumoto take up the matter afresh. That's it.
But the issue involved in this case is, Lordship, this page 21. Lordship, become the page by this 21, the GB's court, that means a Kombora's court, the village court, they have decided the issue. Against this, the private respondent, if he submitted an application to the Deputy Commissioner, which is page 22.
Yes.
And this application, the Deputy Commissioner endorsed this application to the DB's court.
Okay.
The DB's court has no jurisdiction. Deputy Commissioner, he can endorse the matter to the DB's court for trial, not on appeal. That is prescribed under,
That I know.
under Rule
Yeah.
23.
Then,
And as endorsed by the Deputy Commissioner, the DB's court assumed the power and they decided this case. Which
and who, this is being decided by whom? By the PA to the DC.
Worship the B to the in every district, the senior most DBs, that means the senior most Taboshis, he has been designated as a political assistant.
So he acts as not as a PA to the DC, but he acts as the DB court.
DB scope, political assistant. But if we see the Rule 23E, the Deputy Commissioner, he cannot endorse to the DB scope to decide
An appeal.
Yes, Worship, 23E.
No, give it to me. 32, na?
23E, Worship.
23. There is a similar provision in ONHL. It is 32.
23E, Worship.
Page?
Worship, page.
The administration of justice in so and so is entrusted to Iman. And we appointed Dobashi so and so.
23E, page.
The appellate provision?
Page 28. The appellate provision is Rule 31.
31. That is what I was thinking. 31, 32. Appeal shall lie from the decision of the Muzada, Dobashi, or any other duly recognized villager to the tribal court wherever constitution or otherwise, to the deputy commissioner or his assistant. A record shall be made to the matter is necessary dispute and the decision of the village authorities. If necessary, the court shall examine the parties, and if the decision appears to be just, cannot affirm and enforce it as one of its own. The court sheets reasons to doubt the judgment will try the case de novo or refer it to a panchayat. Then,
so Worship, under Rule 31 also, that Worship, the present issue, the original order was passed by the Konbora, that is a village court. Here that under Rule 31, Worship, that appeal lies against the order passed by Konbora and Tobashis to the Deputy Commissioner or his assistants. So it shows that the Konbora and the Tobashis, they have a concurrent jurisdiction. So DB's court cannot sit on appeal against the order passed by the Konbora, Worship.
By the
DB's court, they cannot sit on appeal against the order passed by the Konbora.
It's a Konbora's order.
Yeah, GB's are the Konbora, Worship. Page 21.
Why are you saying that a DB court cannot sit?
You should become the Rule 23A, page 28.
Page
28.
20?
28.
28.
The top, Worship. 23E.
The
Doboshis hand force.
23A.
23A, Worship. This is relevant in the present case. The Doboshis hand force.
Try and decide such civil cases only as may be referred to them by the Deputy Commissioner or the Iman.
You should hear the word try. Shall try and decide. First line.
But what do you say about the 31?
You should Rule 31, under Rule 31 also, Worship. Under Rule 31 also, the DB scope, the Toboshis, they cannot sit on appeal. They don't have the ability of reading.
No, well, to add, no. An appeal shall lie from a decision of the Muzadar, Gauhati chief headman of Khel Dobashis, or other duly recognized village authority to the tribal court. Which is the tribal court?
No, we don't have the tribal court. There's no tribal court.
No tribal court?
No, Lordship. Lordship, tribal court has to function only under rule 40, chapter 4E. Lordship, under the chapter 4E, and the powers in function of the tribal court is mentioned. But under the third amendment, this part, chapter 4 is given appearance.
I admit, your lordship, chapter 4 has not been given effect to. It has not been given effect to.
That 48.
For part,
So there is no tribal court. So only where the appeal lies is to the to the deputy commissioner.
Deputy commissioner.
Now, if the deputy commissioner has been given an appeal lies from a court of a Dubashi to the deputy commissioner, then can the deputy commissioner entrust it to the Dubashi court?
Lordship, I'm saying, be the Dubashi is assistant to DC. Personal political assistant to DC himself has adjudicated this matter. And what I'm contending is that he is also an assistant to the deputy commissioner. My conditions is only that. If my friends say that it is not, then that is otherwise. But I'm saying political assistant to DC deputy commissioner is also a assistant to the deputy commissioner.
How do you say so?
No.
Now,
He's
how
saying
can
no.
No,
He's saying no.
No. That if he is a political assistant to the deputy commissioner, would also be an assistant to the deputy commissioner.
That is what I'm saying.
No, you can say many things. You can even say that the sun rises from the west. But when this court is to write an order, it has to be on the basis of something. What is it? You are saying that he is also the assistant to the deputy commissioner. There has to be some basis.
He's saying no.
No, forget what he's saying. You are making the contention. It is your burden to show it. That yes, a political assistant will also be the assistant to the deputy commissioner. What is your basis?
Political, because
otherwise the division bench out here categorically held, having discussed the way Dubashi cannot be empowered as appellate court by the exercise of powers under 23A. Rule 31 bars DC, ADC and his assistants from such authority. Office of the EAC can be empowered as assistant to the DC under so and so, provided the government declares so. That is the only thing. Then when this is the law, which has been laid down by 2 judges, then I am bound by that. Don't you think so?
Rule 31 has been discussed from para 19.
Assistant to the deputy commissioner in these rules shall mean and include officers appointed as such to exercise powers assigned under these rules, and shall also include officers designated as assistant to the deputy commissioner judicial as and when appointed to administer criminal and civil justice under these rules. So how can you say a political assistant would be difficult?
Rule says assistant to deputy commissioner. That's why political assistant must.
Yeah, it has to be. Can't be like that.
The lordship says no.
Here it cannot be. It has to be either assistant to the deputy commissioner in these rules shall mean. Therefore, the reading of once a postulate the assistant to the any officer appointed as such to exercise here. What can be understood is that an officer other than the DC or AR can be appointed as assistant to the DC. In the administrative hierarchy in the district, after the DC and the next officer in the line is the SDOs and the EAC. The expression shall mean under Rule 1 must be understood as officers below DC and ADC which are referable to SDO and EGC, who are also class 1 gazetted officer in administrative setup. The only rider is such officer must be declared as assistant to the DC. There is no other possible here. So the declaration has to be on the basis of an order.
All the civil STO and all the EACs, they cannot be also assistant to the deputy commissioner. He also has to be appointed. So political assistant, nowhere he comes.
So matter can be disposed. From a perusal of the materials on record, it reveals that a dispute had arisen between
the petition, performer respondent also. Between the performer respondent.
Where is the performer respondent? Between the performer respondent and the petitioner.
In the petitioner. Before the GB scope.
And the petitioner. Before the Gambura's customary court.
Yes, sir.
The Gambura's customary court, by an order dated 27/9/2019, declared the land with home in favor of
the performer respondent.
The performer respondent. Thereupon, who is this?
Is it the private respondent number
3? Who? Oh, yeah. I think the father.
The son.
No, the father.
It's okay.
Yes, I understand.
Yes.
Thereupon, the father of the respondent number 2 filed an appeal before the Deputy Commissioner, Wansang, Nagaland, on 30/9/2019. The records further revealed that certain summons were issued by the PA to the Deputy Commissioner, political assistant to the Deputy Commissioner, and the district head Dobashi Court in charge, Wansang, to the petitioner as well as the private respondents. Thereupon, the political assistant to the Deputy Commissioner, Wansang, passed the order dated 20/10/2020 the whereby the direction given to the petitioner to repay a sum of rupees 35,000 to the performer respondent number 4. Performer respondent?
Yes, performer respondent.
Was affirmed. Affirmed, no?
No, Lordship. These are fresh penalty.
Huh?
Fresh penalty. This is to pay a sum of rupees 30,000.
35
35,000 Lordship.
to repay a sum of rupees 35,000 to the respondent, performer respondent number 4. And thereby, it was decided in favor of the performer respondent number 4 and against performer respondent number 4 as and whom?
Name of the party is not given in the impugnment.
That is what the problem.
Yes, Lordship.
And the respondent number 1 in the said proceedings. It is against this order that the petitioner has approached this court by filing the instant proceedings. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the PA to the Deputy Commissioner had no authority or jurisdiction to pass the said order in view of Rule 1C, read with Rule 23A and 31 of the Rules of Administration of Justice and Police in Nagaland 1937, for short, the Rules of 1937. In this regard, the learned counsel has referred to the judgment of the division bench of this court in the case of LMTMC, Jamir and 3 others versus the state of Nagaland and 6 others, bracket WPC number 164/2017, dated 4/12/2020. Mr. So-and-so, appearing on behalf of the respondent number 1, submits that there is no infirmity in the impugned order as regards jurisdiction and authority, in view of the fact that the political assistant to the Deputy Commissioner is also an assistant to the Deputy Commissioner.
As per the rules.
As per the rules of 1937, for which no interference required to be made. This court further finds it relevant to observe that the private respondents, however, are not represented, though their names have been duly reflected in the cause list. This court have duly heard the learned counsels for the parties, as well as have also perused the materials on record. The only issue which arises before this court as to whether the impugned order dated 2010-2020 passed by the PA to the Deputy Commissioner, Tuan Sang, is required to be interfered with for on the ground of jurisdiction. At this stage, this court finds it relevant to take note of the judgment of the division bench of this court in LMTMC Jamir bracket Supra, wherein the issue as to who can exercise the powers under Rule 23A of the rules of 1937 was decided. The division bench of this court in the said judgment had taken into consideration Rule 1C, which defines the term, inverted comma, assistant to the deputy commissioner. And observed that the said term has to be understood as any officer other than the DC or the ADC can be appointed as assistant to the DC. It was further observed, opined, that in the administrative hierarchy in the districts, after the DC and the ADC, the next officers in the line are SDOs and EACs. Further to that, it was also opined that the expression, inverted comma, shall mean and include officers appointed as such, inverted comma close, under Rule 1C, must be understood as officers below DC and ADC, which are referable to SDOs and EACs, who are also Class 1 gazetted officers in the administrative setup. The only rider to this, as opined, the only rider which was mentioned in the said order, said judgment, by the division bench of this court, is that such officer must be declared as assistant to the deputy commissioner. Under such circumstances, in the said case, the division bench held that the EAC can be declared as assistant to the DC under the rules of 1937. In the instant case, it will be seen that in the instant case, the learned counsel appearing on behalf of the respondent failed to show any document that the political assistant to the deputy commissioner had been declared as assistant to the deputy commissioner. In absence of any such document, the question of the political assistant to come within the ambit of the term assistant to the deputy commissioner does not arise. In the backdrop of the above, let this court therefore take into consideration Rule 31 of the rules of 1937, which provides the provision of appeal from the decision of the Mojada, Gaungura, chief, headman of Khels, Dobashis, or other duly recognized village authority to the tribal court whenever constituted, or otherwise to the deputy commissioner or his assistant. It has been stated at the bar by the learned counsels appearing on behalf of the parties that the tribal courts are yet to be constituted, and in terms with Chapter 4A of the rules of 1937, which is yet to be notified. Therefore, an appeal against the authorities, and more particularly against the decision of the Gaungura, has to be before the deputy commissioner or his assistant. In the instant case, the appeal was duly filed before the deputy commissioner by the respondent number 2. No?
Respondent number 2, father.
By the father of the respondent number 2. But it was neither decided by the deputy commissioner or his assistant. Rather, it was decided by the Dobashi court, wherein the political assistant to the deputy commissioner was also the village head. What is his name? Is also the
he's the head of the DV.
Which decided by the which was decided by the political assistant to the deputy commissioner. It is also seen that assistant to the deputy commissioner, as could be seen from the impute order itself. It has also been submitted by the learned counsel appearing on behalf of the petitioner that the said political assistant to the deputy commissioner also enjoys the post of the status of a district head, Dobashi court in charge of the said district. At this stage, this court finds again to refer back to the judgment of the division bench in the case of LMTMC Jamir Supra, wherein at paragraph number 23 it was categorically observed that the